state as to regarding the criminal mischief of felony, there is no allegation of financial loss.
No, I agree.
So I will find probable cause for misdemeanor criminal mischief. I will find probable cause to burglary, occupied structure, interference.
I have argument 16808, Judge. Number one, there at best will be probable cause for a trespass. There's no intent to commit a crime therein. With regard to custody interference by by a parent, it indicates that Ms. Florent is the mother of the children. There's nothing indicating. First of all, it states that they're not married, they're boyfriend, girlfriend. There's nothing indicating that the alleged victim obtained parental rights or has any legal rights to custody of the children, and has determined that he is the biological father of any of the children. There's nothing in the arrest form to indicate the same, Judge. So she can't interfere with the parent when she is the biological parent.
But she's not allowed to shove him while she's in the house, taking the kids away from him, and then try to rip his license plate off.
That was outside.
It's all still within the curtilage of the house because it's all still within where the parking area was, and there's a mentioned gate that she walked through. So she opened a gate and then entered the house. So if it's a gated in yard, she's still in the curtilage and it's still a burglary.
It looks like the alleged victim had the children without her permission.
And it looks like
it says that defendant did not have permission from victim one to take the victims. It's the other way around, man.
Well, if she's the biological mother and there's nothing, and their boyfriend, girlfriend, there's nothing indicating, then he has legal right to the children.
But there's nothing indicating she does either.
She's the biological mother,
and we don't know that he's not the biological father.
Well, if it's
but
not,
the children were with him.
That doesn't mean that you have a legal right to them.
But it doesn't mean you have the legal right to come into the house and take the kids away.
Who's got the legal right to the kids?
What would I'm going to ask you all just to give me some direction. What would Judge Glazer do? Listening to both of you,
Judge Glazer's here every
argue
day
at each other,
asking if the boyfriend who says they're the father of the child has not gone to get parental rights, they legally do not have any legal right to the custody of the child, and they have to go file downtown. And she explains to the fathers what they need to do in order to have legal status for the children.
There's no let me suggest something to both of you. Rather than argue at each other, why don't you address your comments to me and let me make the decision?
Understood. Well, I'm not as
hold on a second. I was taking a breath. The allegations are that the alleged victim is the father of the children. The allegations are that the defendant unlawfully entered the residence of the alleged victim and therein committed a battery on the alleged victim. That is burglary.
Judge, if I may, I'm missing where it says the alleged victim is...
The defendant pushed the victim.
I understand they're claiming that they're a victim.
The very first sentence of the
whether or
arrest
not
form.
in the arrest form that it states that the alleged victim is the father of the children.
Ma'am, I'm not talking about the father of the children. I'm talking about the burglary.
If I may.
Stay. Let's not talk over each other. I don't know whether this Zoom, you all are not hearing me. Burglary is the entry, a trespass with the intent to commit an offense. The defendant entered the defendant's house and committed a battery upon him. That is burglary. I find probable cause for the burglary. I find probable cause for the battery. I find probable cause for criminal mischief misdemeanor. I do not find probable cause for interference with custody. The bond on the burglary will be $2,500. ROR on count 2. 2,500 on the battery.
Judge, there's 3 counts of interference.
I'm sorry, RR on the 3 counts. Thank you. $2,500 on the battery.
Would you do standard bond, Judge, on that? Standard bond's 1,000.
1,000. 150 on the criminal mischief and 150 on the second, on 809. It's a misdemeanor bond of criminal mischief. Good luck to you, ma'am. I'm gonna enter. What is the gentleman's name?
The father's name is Laventure Themidor.
Laventure, okay. I'm gonna enter a no contact order. I assume that they don't live together, correct?
Correct.
So I don't have to worry about the defendant having to appear at the house to retrieve their properties, right?
Correct.
Okay. Now, good luck to you, ma'am. Now, let me ask you, counsel, because I'm not sure how your Zoom connection here works. And I think Judge, is it Glazer or Glazer? Judge Glazer's JA told me that it appears that when somebody else but the judge is talking, the judge, if I speak, you all cannot hear me. Is that correct?
That's the way it is with courtroom 1-5.
How about it right now? Is it that the way it is?
If I'm speaking now, why don't we speak at the same time? I'll see if we can.
All
hear
right, 1, 2,
you. Speaking
3.
at the same
What
time.
time is it?
I can hear you.
Okay. Can you hear me, State?
I could hear both of you while you were talking.
All right, thank you. So do me a favor. I understand that you all get rather excited and talk over each other. But do me a favor. If you hear me talking, can you pause?
Yes.
And let's see where we go.
Thank you.
Thank you.
They have some ladder turns ready.
Hold on a second.
No problems.
All right, the other, this gentleman,
This is up top and then number 11 is right after this. This is 20 and 11 coming up next. And these are all the corrections.
what page? So they can know, they go to the pages. Page 8 is number 20,
Mr. Fraga.
Michael Anthony Fraga.
Good morning, Your Honor. Lawrence Fessler on behalf of Mr. Fraga.
Counsel for the state, can you hear counsel for the defense?
I could hear him introduce himself, yes.
Okay,
Judge, I know you're gonna find this shocking. I went up to the 9th floor to get the arrest report and they said, oh, no, you have to go get it on the third floor where the bond hearings are at. So that's where we're at, Judge.
okay, let me read it to you.
The only thing I'm concerned about the bond, first of all, he's on probation, so there's gonna be a probation hold no matter
Correct.
what.
Correct.
My only concern is it's charged in the arrest report as leaving the scene with serious bodily injury. So I need for Your Honor to concentrate on what, if anything, is in the arrest report to establish probable cause as to A, bodily injury, or 2, serious bodily injury, which is defined in the statute as a physical condition that threatens risk of death, or serious permanent disfigurement or impairment of an organ.
All right, just bear with me because it's a novel.
If I may, Judge, if I may save a little trouble there, the answer to that question is on the last page of the arrest form near the bottom, where it says the victim sustained a fractured left ankle, which should be sufficient for serious bodily injury.
Judge, if it's a fractured left ankle, that would be bodily harm. I don't know that that even comes close under the definition of serious bodily harm under the statute, which again reads physical condition that threatens risk of death. Obviously, a broken ankle doesn't involve risk of death, or serious personal disfigurement or protracted use of a bodily member or organ. So if that's what it says, a broken ankle, Judge, I would ask Your Honor just to find probable cause as to bodily harm, which is a third-degree felony, not a second-degree felony, and set the bond commensurate with a third-degree felony instead of a second. And in any event, it's all going to go back in front of Judge Hirsch for review on the probation hold. He's not going anywhere.
Let me ask you a hypothetical question.
Yes.
Do you represent personal injury cases?
No, I don't. Well, not in years, Judge.
Because Morgan & Morgan would say that this is a very grievous, serious injury to a bodily function. So a broken ankle is a serious bodily injury. In any event, he has a detention hearing. What would the state's recommended bond be?
So I would, keeping in mind what everything the defense attorney has just said, instead of asking for the the full F2 amount, I'm willing to go for a reduced, say, $3,500.
There you go. And I would set a $3,500 bond instead of the, I believe it's $7,500.
That's fine, Judge.
And a detention or,
Do we have a date for a set in front of Judge Hirsch yet?
yes, that's what I'm gonna ask. What will be tomorrow?
Tomorrow.
So I will put a hold on the violation of probation. Right.
And set 9 o'clock in front of Judge Hirsch tomorrow?
I believe it's 9 o'clock. Is that correct, Madam Clerk?
Yes.
Thank
All
you
right,
so much.
thank you. Nice meeting you, Counsel.
Have a safe trip back to Judge.
Thank you, sir. I believe the next person is page 5, Sylvia Ugilis Wartan.
Good morning, Judge. I was on Zoom and now I'm in person.
All right. Well, we have an officer here.
Morning.
For purposes of the state, since you're not here, state, we have a private attorney representing the defendant, as well as, I believe, the detective that was involved in this arrest.
Judge, I have not had the benefit. I tried to get the arrest affidavit, but I'm not able to see it. I don't know if the officer has an extra copy. I could just take a look at it. As long as the court's okay with it out.
Yeah, I don't have any problem. I mean,
Take the Spanish interpreter, please.
Yes, ma'am.
Ms. Urgiles, do you speak English?
Señora Orguiles, ¿habla usted inglés?
No.
No.
What are you all talking to me about?
Talking to each other. I'm looking for the other apron that you just did.
I put it here. Are you talking about Fraga?
Yeah.
I just put it here.
There.
I'm sorry, counsel and officer. The clerk is looking for something that I obviously have misplaced, or you found it?
Popping around.
No problem.
Spinning around.
Okay, we're back to Ms. Urgiles.
Bien, nuevamente con la señora Orguiles.
Counsel for the defense is reading the narrative.
El abogado de la defensa está leyendo el narrativo.
The officer state is before the court to ask the court to note the Nevia requirement that they have requested.
I'm sorry, Your Honor. You said the officer is asking,
Is before the court
yes, Your Honor,
to speak on behalf of the Nevia
requirement.
requirement that they have requested.
Yes, thank you, Your Honor. Bien, el agente se encuentra ante el tribunal sobre el requisito Nevia que han solicitado.
The defendant is charged with sale, purchase, or possession of counterfeit label products, $20,000 or more.
Bien, la acusada ha sido imputada de la venta, la compra o la posesión de artículos falsos en una cantidad de $20,000 o más.
There is a second Z as in zebra -O, hold for magistrate. I'm not sure what that means.
Bien, hay un auto de detención Z-O de parte del magistrado. No estoy seguro de lo que esto significa.
Madam Clerk, you were saying something.
It's the Nevia sold.
Well,
It's a
First
hold for
appearance.
first appearance, Your Honor.
yes, ma'am.
Es una retención por la primera comparecencia.
I'll hear from counsel.
Judge, I'll stipulate that there's probable cause for counterfeit merchandise. I can say my client has no prior criminal history. Typically what we see in the requirement for that is something between the drug sales, drug trade. I've never seen a Nevia requirement for a situation like this where there's allegedly counterfeit goods that are being sold.
Just a
I
moment,
think- I
please,
think-
for the interpreter. Thank you. Su señoría, está hablando el abogado de la defensa. La defensa está dispuesta a acordar en que hay causa probable para el cargo de la mercancía falsificada. La cliente no tiene antecedentes penales anteriores. Esto no se trata de venta ni de comercio de drogas, de tráfico de drogas. Nunca he visto que se solicite un requisito Nevia.
Judge, additionally, what it's going to do is it's going to keep her in jail for a couple days so that we can have a family member post the bond. And in a situation like this with someone with no prior history, I would ask the court just set a standard bond.
Well, but the allegations are that the deceased.
Bien, el abogado de la defensa ha añadido que su señoría le vamos a mantener en la cárcel por un par de días para que un familiar pueda venir a pagar la fianza. En este caso, solicito de que se le imponga el monto reglamentario de fianza, pero las acusaciones, indica el señor juez,
That there are a number of thousands of counterfeit sets that were seized to the tune of over $500,000. So it appears that that's a substantial amount of money that is alleged to have been seized of counterfeit goods. And it appears that the majority of the business may be subject of the income might be subject to counterfeit.
Here's the issue, Judge. They're using retail value from Adidas. That's not what the items are being sold at. So if the retail value is $50 for a shirt at Nordstrom's and they're selling it for $5, that's where they're getting it from. Not that that she's making that kind of money,
Right,
but they're using a retail value as counterfeit
sure.
to establish the amount. But that's not what she's selling it for.
If I may interrupt,
Yes, ma'am, sir.
it says on the, I guess, the third or fourth page after it talks that whole list of the things they recovered. Further investigation revealed that the business was selling soccer shirts at prices of $28 for an individual set, $300 for 12 sets, all the way up to $750 for 30 sets. So are you saying you don't believe they were using those numbers to get to where they were at? Because I mean, I haven't done the math, but they give numbers for what she sells the clothing at.
But those are not retail values.
Your Honor, if I may.
Yes.
I may be able to clear it up. Counsel is correct. By statute, generally, we do retail values. She's selling at 20% of the face value. So even at 20% of the face value, we're still at $100,000. We're well beyond the threshold of second degree.
No, yes, counsel was arguing about the Nevia issue.
Well, with the Nevia as well, he gave a good example. We normally use this for narcotics. Narcotics, we use this because it's contraband. In and of itself, counterfeit goods are contraband.
Yes.
They're destroyed in the same fashion.
Yeah, I'm gonna set a Nevia here, but let me hear the state recommendation with regards to bond.
If I could, may I please interpret for the defendant?
Yes, ma'am, that's your job.
Yes, Your Honor, thank you. Bien, el señor juez ha dicho de que se han confiscado miles, incluso hasta medio millón de dólares, de que esto es una cantidad importante, una cantidad grande de mercancía falsificada. El abogado de la defensa ha dicho de que se estaban vendiendo a valor, no se estaban vendiendo al valor minorista. El abogado fiscal ha indicado de que sí lo estaban vendiendo y las cantidades de la mercancía, y el abogado de la defensa ha indicado de que en un 20% sería llegando a la cantidad de $100,000 y que esto estaría en el límite para calificar como delito mayor en el segundo grado.
State, now you recommend the bond.
The standard bond is $7,500 for this count. The state would ask for $10,000 as an elevated, given the way she was trying to dodge the police and the fact that the sheer scope of 3 different stores all doing this at that volume.
Bien, la fiscalía recomienda que se le imponga monto elevado de fianza de $10,000, aunque la fianza reglamentaria es de $7,500, y esto es debido a que ella estaba tratando de eludir a la policía, y esto fue en 3 establecimientos.
How long has Ms. Urguiles Huertan been in the country?
She's been in the country, I think, well over 10 years. She has 3 children. She's not a citizen, but a resident here. Her ties are to this community.
Your Honor.
Bien, el abogado de la defensa ha indicado de que la señora Arquiles ha estado en el país más de 10 años, tiene 3 hijos, no es ciudadana de los Estados Unidos, pero sí es una residente permanente y tiene vínculos en esta comunidad.
Your Honor, I would say the state's recommended bond of $10,000. I have no issue with that.
Su señoría, yo diría de que no tengo problema con la sugerencia de la fiscalía de $10,000 de fianza.
I would set the bond at $10,000 with the Nevia requirement.
Yo voy a fijar el monto de la fianza en $10,000 junto con el requisito Nevia.
Good luck to all.
Thank you, Judge.
Bye-bye.
Buena suerte a todos.
All right, let's talk about that. This hearing really ran the gamut from a custody dispute that turned into a curtilage debate, to counterfeit soccer shirts, to a philosophical moment about broken ankles. Judge Chris Martin had his hands full, and to his credit, he navigated it with a solid balance of firmness and patience. The standout moment early on was the discussion over whether a mother who forcibly entered a gated yard and allegedly committed battery on the father of her children had actually committed burglary. The debate between the state and defense over legal rights versus biological status was fiery, but Judge Martin smartly reminded everyone to address him, not each other. He calmly sorted through the noise, ultimately finding probable cause for burglary and battery but not for interference with custody, carefully dissecting the legal distinction between biological parenting and court-ordered custody rights. Then came a moment of real-world practicality when he confirmed that the mother and alleged victim didn't live together, neatly avoiding the need for a property pickup clause in the no-contact order. Things then took a turn into personal injury. Court humor, when a defense attorney quipped about Morgan, and Morgan probably calling a broken ankle a very grievous injury. Judge Martin didn't bite, but he did adjust the charge from serious bodily injury down to bodily harm, rightly pointing out that a fractured ankle, while painful, doesn't typically threaten life or limb in the statutory sense. He set a $3,500 bond in recognition of the downgrade, which seemed a fair middle ground. But the real showstopper was the counterfeit goods case, $500,000 worth of allegedly fake soccer gear spread across 3 stores. That one included a full translation relay, math on margins, and whether Nevia conditions should apply. The defense argued the clients sold the items at steep discounts and shouldn't be hit with the kind of requirements reserved for narcotics trafficking, but the state countered persuasively that counterfeit goods are contraband too, and pointed to active attempts to dodge law enforcement. Judge Martin again struck a balance, accepting the probable cause, imposing a $10,000 bond, and requiring Nevia not because of the dollar value alone, but because of the scope and effort involved. Overall, the hearing was full of sharp exchanges, some solid legal reasoning, and more than a few moments that'll stick with you if you've ever wondered how the finer lines of custody law, retail math, and ankle definitions get drawn. Judge Martin kept the proceedings grounded and orderly, even when they threatened to veer into chaos. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.